You're entitled to testify if you want to testify.
Oh, no, oh, no. Testify as an expert witness.
An expert in what?
I'm an expert in my own religious beliefs after studying comparative religious beliefs. And my religious beliefs are what motivated the conduct that the district attorney finds criminal, and which is no means is criminal. So I can testify as to Mr. Blandino, religious beliefs, how they've been developing and evolving over the years, and how that his main belief is not to do crimes.
State of Nevada versus Kim Blandino, case C-341767. Who is here on behalf of the state of Nevada?
Mike Dickerson on behalf of the state of Nevada, Your Honor. Bar number 13476.
Thank you. Mr. Blandino, would you like to make your appearance?
Okay, how's that?
Perfect. Go ahead, you can make your appearance.
Kim Blandino appearing pro se by Blue Jeans. They won't let me in the courthouse without a mask, and so I can't wear a mask, and that's why I'm appearing here. Necessity.
Thank you. And Mr. Bateman, do you want to make your appearance?
Yes. Good afternoon, Your Honor. Ben Bateman, bar number 9338. I'm standby counsel for Mr. Blandino.
Okay. Thank you very much, and thank you very much.
Right off the bat, there is no way you can proceed forward. Tiara Jones has an unadjudicated motion to disqualify against her that was filed.
Mr. Blandino, I am going to proceed. And if you interrupt me, then I'm going to have the clerk mute your microphone. Okay?
I object to you.
I am going to proceed. You can object. I understand. You object to me proceeding over this. I got it, and the record will reflect that. So the first motion, the state's motion to remand the defendant or order additional conditions of release. Mr. Dickerson, do you want to be heard?
Yes, Your Honor. Thank you. So this motion was placed on calendar back in February of 2021 based upon the defendant sending the state
2020?
20. I'm sorry. Yeah, 2020. The state sending.
It's been about a year and a half.
That's correct. The state sending the defendant sending the state a letter indicating extremely concerning things about him going to the named victim's home as well as municipal.
I object. It was a discrete distance.
Okay.
Not to his
You can speak after me.
Interrupt the district attorney. If you proceed on interrupting people when they're talking again, I will mute your microphone. Mr. Dickerson, you may proceed.
Thank you, Your Honor. The defendant sending this letter to us indicating he's going to visit the named victim's home as well as another judge's home, and pretty much indicating in there that, hey, guess what? Looks like I'm no longer on high-level electronic monitoring, so I can do what I want, and the condition of no contact does not apply. I would suggest that since it has been such a long time, without a doubt, the court should, at the very least, make sure that it is clear that the condition of having no contact with the named victim, and I would also submit as well as any other sitting judge or pro tem judge in Clark County, since obviously that's the basis of what he's indicating here during the time of his release on this case. That would be at a minimum.
Okay, and so I know that the initial no contact order was asked to Mr. Federico. Is that correct?
That's correct, Your Honor.
And then I thought there was another judge that I guess presided over a TPO hearing, and that judge was a temporary judge as well?
The Shannon Nordstrom is a judge that the defendant has become fixated on over the years, and that's who he was indicating within the letter that he was going to also go to her house to conduct some sort of surveillance upon her residence.
Okay. All right. So the state is seeking to just make sure that he understands those conditions?
Yes, Your Honor.
Okay, Mr. Blandino, do you want to be heard?
Okay. Again, I got to renew my objection. I'm only speaking. You don't have the capacity to move forward, but since you're forcing me to move forward, and I got to defend myself against illegal acts, namely you sitting on here when there's an motion.
Listen, Mr. Blandino, I'm not gonna go through this every time you have an opportunity to talk.
Well, here, to
You
his,
filed about 4 motions to disqualify. Each and every one of them have been denied. I have jurisdiction and we're going to proceed. So if you want to talk about this specific issue, you may.
okay, I'm
Go
going
ahead.
to have, because they're trying to do something illegal here, and they're lying again on the record. I said that I would maintain a discrete distance to view that home, which would be any discrete distance that would normally be in a temporary restraining order or a protective order. The thing is that it was subsequent to filing a suit, which I have now filed. The court can take judicial notice. I filed a federal suit against Michael Federico for abuse of process. I have a responsibility filing the suit to investigate, to see if there's anything regarding that. But in absolute truth, and I state this under penalty of perjury, I have not visited Federico's home. I'm not visited Nordstrom. It's in light. The reason I sent this, and it's not really a trial balloon, but I sent this notice to Mr. Dickerson and to the other parties in that note, was to see if there was any fuss made about it. And I got the ankle bracelet to prove it. I haven't been anywhere near those persons. And the court doesn't have to make any conditions. I just say I'm not going to do that until that's resolved. But the point has to be that Judge Bell, when I got back from LCC, over my objections, against my will, I said that you can't really do, you're a competency court judge, and you can't really do conditions of custody. But she's nonetheless said, dropped it from, she knew it was high level before. She said, I don't think that's necessary. She put it on medium, and she didn't set any other conditions. I double checked that with my house arrest officer, Daniel Webb, and he said, Kim, there's no conditions on you whatsoever. And I said, well, I'll still let you know when I'm going to a sensitive area, like to the municipal court or whatever, because at municipal court I could run into these people, Federico or Shannon Nordstrom. And I object to Mr. Dickerson's characterization that I don't know how you put it, didn't say obsessed with Shannon Nordstrom. I've got a file, and my statute of limitations is running off on that. Both of these people, Federico and Nordstrom, filed frivolous temporary protective order requests with the Justice Court, and they were denied outright. We did have a little hearing on Shannon Nordstrom, and with Jansen on the Federico one, he did that. So they've abused process. Federico, their complaining witness, lied and perjured himself. And as a matter of fact, Dickerson and Melanie Marlin were...
I don't think that any of this is relevant, so I'm going to stop you right there. I am going to deny the state's motion to remand you. I'm going to allow you to stay on house arrest. However, I disagree that there were no special conditions. At no time was that no contact order lifted. So I just want to make sure you understand you are to have no contact with Mr. Federico and or Miss Shannon Nordstrom. Do you understand
Federico.
that?
Yeah, there's Federico. No first R in there. It's not Federico, it's Federico.
Okay, thank you very much. Thank you for correcting me, Federico. Okay, and so Mr. Dickerson, you can prepare the order on that. And then
So,
now there's a...
It's just to stay away from Federico and Nordstrom, right?
That is correct.
Okay.
That is correct. I do not believe that the no contact order was ever lifted. So, Mr. Dickerson, I think the next motion, let's see. The state's motion regarding his self-representation.
That's correct, Your Honor. As you'll recall, this motion was originally filed back in November of 2020. And at that point in time, it was heard, the court in December 17th of 2020 essentially held the motion in abeyance and indicated that you weren't going to grant it at that time. You were going to wait and assess how the defendant behaved going forward in this case. The state has since that time filed 3 supplements to that motion detailing every time the conduct that the defendant has shown throughout the course of this particular case and outside of this case as well. That includes what we'd previously been discussing of the letter that he sent to the state indicating that he's going to go conduct this covert surveillance upon the victim and Municipal Court Judge Nordstrom. In addition to that, after that January 2021 letter, we have a series of motions to disqualify that have been filed. That begins March 8th, 2021. That is what I've called in my moving papers the third motion to disqualify, or the fifth motion to disqualify. April 14th, 2021, the sixth motion to disqualify. April 22nd, 2021, the seventh motion to disqualify. May 6th, 2021, the eighth motion to disqualify. May 18th, 2021, email to your court staff that was extremely disparaging. August 10th, 2021, Judge Wilson issued his order denying what he termed the third motion to disqualify against you, Your Honor. He also indicated within his order that all of these motions that the defendant had been filing were in fact illegitimate, and they were only filed to gain a tactical advantage. This and goes on to my analysis of the abusive process that the defendant has continued to show during this time that this state's motion to revoke his right to self-representation has been held in abeyance. And so we filed this third supplement to the motion to revoke his right to self-representation. We filed that on August 13th, 2020. In there, you see that I've also indicated under Indiana v. Edwards the extreme concerns that we see as far as the defendant's diagnosis of having a personality disorder, specifically a personality disorder that includes obsessive, schizotypal, and prominent narcissistic traits. Looking to the Mayo Clinic's definition of what that entails, we all get an idea of exactly what is going on here and what the problem is. You see that a personality disorder is an rigid and unhealthy pattern of thinking. And then from there, getting into the typology of his personality disorder, we see exactly why he continues down this path of the abusive process and refusing to acknowledge orders of the court, specifically the order of Judge Wilson, which has already indicated that his filings were illegitimate, because his response there too is then in the next days, August 18th, 2021, he then files his 9th and 10th motions to disqualify, including a motion to disqualify all of the district court judges in the 8th Judicial District, which was specifically referenced by Judge Wilson in his order as being one of the bases for him determining that these were illegitimate motions that he was filing. And then to go further, a few days after that, August 23rd, 2021, as of yesterday, he's now filed his 11th motion to disqualify. This is a continuing abusive process that the defendant is going to continue down. We are in a position right now where it has become clear. It's become clear under Ferretta that the plain terms of the U.S. Supreme Court's seminal decision on self-representation provides that this does not provide a right to abuse the dignity of the courtroom. It does not provide a right to avoid compliance with the relevant rules and procedural and substantive law. And it does not provide a right to engage in serious obstructionist misconduct, which is exactly what the defendant is doing. And case in point, when we started off this hearing today, the defendant, after the court having issued minute orders denying his motions to disqualify, begins this proceeding today by saying, Your Honor, you do not have jurisdiction to hear this case and not proceed today, because it evidences exactly what he has been doing. These are his obstructionist misconduct to delay this case and file these motions only for a tactical advantage to achieve that delay. Based upon that, I think he's left this court with no other option but to revoke his right to self-representation, because he continues to abuse the process, and it's clear that he's going to continue from this point forward.
Are you done, Mr. Dickerson?
I am, Your Honor.
Okay, Mr. Blandino?
Okay, well, he's lying through his teeth again. Really unfortunate that he violates his own code
Mr.
of...
Blandino, I am not going to permit you to call the attorneys or anyone a liar. I just
Okay.
want to hear what you want to say in opposition. Do not make disparaging remarks about the district attorney or anyone else involved. It's not appropriate.
Well, would you prefer the term of candor? Is that appropriate?
No, I don't want you to say anything to the district attorney. I want you to oppose the motion.
In fact, Judge Wilson did not say I did. He said he was concerned that Mr. Blandino thing, and he used the term concerned to gain a tactical advantage or to delay the. But the thing is, Mr. Dickerson misleads the court when it says 10 motions to disqualify. This is one of the main factors into which I went into investigating judicial corruption and misconduct, especially in the 8th Judicial District Court. The court does not want to follow NRS 1.235. They want to make the law up as they go. For decades now, they don't follow. When the motion to disqualify is filed, only a challenge can be brought within 5 days. If the judge decides that they're not going to challenge the motion to disqualify, it is their obligation to immediately transfer the case. And then the thing is, if they do file a challenge, it's supposed to be by a party, heard by a party, agreed upon by the parties, and if they're can't come to an agreement, then by a judge appointed. But the 8th Judicial District, trying to become its own legislature, in essence says, no, we're going to have the chief judge hear all of these motions to disqualify. So it's been Judge Bell, now the current chief judge. Before that, it was Judge
Blandino, do you have anything that you want to say in response to the state's motion? They're asking me to revoke your self-representation.
Every one of these motions to disqualify have been based on facts and evidence that Kim has that he cannot have a fair trial by any 8th Judicial District Court judges. This judge can, as you can take judicial notice of in the Marlon Brown case, I am going to have to call multiple judges as witnesses. And in the Marlon Brown case...
Okay, that has nothing to do with this case. If you don't want to talk about this particular motion, I will just rule on the pleadings. But it is very clear to me that, you do not want to follow the rules. You don't want to follow the rules. And you continually, do this obstructionist behavior and try to impede and obstruct the state from moving forward. You were able to obstruct the state from being heard on their motion to remand you for over a year based on these motions to disqualify. It's not right. If you don't want to follow the rules, I'm going to revoke your self-representation. I want to make sure you understand. Self-representation is not absolute. If you do not comply with the rules, I will revoke your self-representation. You will be appointed an attorney, and your attorney will litigate this case, not you. Do you understand that?
Well, I'd like you to point out to me, Judge.
Do you understand that?
Rule did I not follow? I don't know. I'm the one that followed NRS 123L1.235, and at no time did Judge Wilson state that my motions to disqualify were frivolous. He said it was to gain a tactic.
They are not made in good faith. I believe that you filed these last motions to disqualify to prevent the state of Nevada from having their motions heard. And you were successful in preventing them from having their motions heard. And then when it gets back on calendar, even though your motion has been denied, you simply file another one.
right, we're back live.
He was a potential danger to his children.
We're here for the court's order to show cause.
Okay, so that takes care of one motion.
Maybe somebody can tell me what the status is.
Any preliminary issues we need to take care of?
We'll make sure that she's As you know, the Supreme Court has
I don't understand what you're trying to do. Don't you want to proceed and get this over with?
Judge,
I mean, don't you want to get this over with?
Judge Dear Jones has an unadjudicated motion to disqualify. She cannot jump in front of Judge Wilson. Judge Wilson did not dismiss that motion to disqualify with prejudice. And so I had made the natural, he said I didn't have specific facts in there. So I had to presume that the denial and the dismissal was without prejudice, and that's why I filed an amended motion with additional facts with exhibits. It's 1,300 and some odd pages.
All right, Mr. Blandino. I mean, I'm going to tell you that you are very disruptive. You don't follow the rules. You think that you're above the rules and that you're not required to follow the rules. A case in point is that we have rules about how people have to appear in the courtroom. If you come in the RJC, you have to wear a mask. Otherwise, let me finish. Otherwise, we allow people to appear via blue jeans. Every other person that comes to the RJC complies with that. You refuse to comply with that. You wouldn't even appear via blue jeans because apparently you don't have to follow the rules. That is not true. You are required to follow the rules. If you don't talk, don't talk. If you want to appear in the Regional Justice Center, you will be required to follow the rules and wear a mask. Otherwise, you can appear via blue jeans like every other person that has business in the RJC. I don't make the rules. I just follow the rules. And I'm not going to allow you to just simply disregard the rules.
Can I rebut? Yes, I got a note from a doctor. I appeared on August 10th before the Board of Examiners with with the governor. I was 6 feet away from him without a mask, and he was no problem with that. This is on YouTube. The court can take judicial notice. I showed his staff this doctor's note, and he allowed me to make public comments twice, at the beginning and at the end, with this doctor's note that I cannot wear a mask. In addition to the medical,
you appear via blue jeans. That's fine. I mean, you are appearing via blue jeans today, and that's fine. But for the last year, you have refused to appear even by blue jeans, and you stand outside the courthouse without a mask on, and you demand to be let in, and you have to be told you cannot come in. So again, I just want to make sure you understand. You don't want to wear a mask. You have a medical condition. I don't need to know about it. You can appear via blue jeans. That's fine with me. I have absolutely no problem with that.
I have a problem with blue jeans. I can hardly make out your face at all. I can't tell what's going on with your facial expressions. I need to have feedback. I'm 66 years old in October, and I have problems.
I am not going to argue with you. These are the rules, and that's what you can do. Okay? It is what it is. I'm not going to let you just bypass the rules. You are not above the rules. And again, I want to make sure you understand, self-representation is not absolute. You have obstructed and impeded for over a year by your refusal to follow the rules. And then when the state comes close to having their motions heard by the court, you simply file another motion to disqualify, even though for an entire year there's basically nothing going on. So again, I just want to make sure you understand, you are not entitled to ignore the rules. Your behavior is disruptive and you obstruct and impede. If you continue down this path, I will revoke your right to represent yourself. Do you understand that?
Well, I understand what you're saying, but I respectfully, I'm following the rules and I'm following the statutes, and it's the 8 Judicial District Court judges that aren't following the statute.
Okay. All right. Again, it sounds like you understand me, because I'm not going to allow you to continue to make a mockery of the court system. Do you understand?
I understand what you're saying.
Okay, so if you continue with this obstructionist and impeding behavior and refusal to follow the rules, I will revoke your self-representation. Do you have any questions about that?
I don't hear any specificity on what you're just in a conclusory fashion saying I'm abusing the thing by filing these motions to disqualify. And contrary to what Judge Wilson states, I am sincere that I don't believe I can get any kind of fair trial with any 8 Judicial District Court judge. And Marlon Brown was allowed to have all of those recused, and he had co-sach assigned to his petition for writ of habeas corpus.
Again, you don't think you have to follow the rules.
No.
So I just want to make sure you understand. So at this point, I'm going to deny their request to revoke your self-representation, but I want to make sure you understand there is enough in this record right now for me to revoke your self-representation. So if you continue down this road, I'm going to revoke your self-representation. So I suggest you follow the rules and that you stop with this obstructionist behavior. So the next one is, let's see.
Can I make one quick record on that, Your Honor?
You may.
The defendant misstated the ruling of Judge Wilson specifically, and I quote, Judge Wilson says, I conclude Mr. Blandino's disqualification claims are not legitimate, that they were made to gain tactical advantages in his criminal case before Judge Leavitt. This is something the defendant needs to understand as he moves forward. It's clear today, listening to him, that he intends to continue down that path despite the court's ruling. So I just want to make it very clear that our position is he should still have his representation revoked today, despite the warning. Your Honor's found that there's the basis for it, that he's committed serious obstructionist misconduct. It's really just giving him another opportunity for another years-long delay based upon these continued motions to disqualify, which are illegitimate.
Okay, well, I can assure you I will not let it go on for a year.
On that, Judge. So if I take this issue of the motions to disqualify, which now I have a factual record, because they're saying they're not a fact finder. So would I be not following the rules if I appeal this denial to the Nevada Supreme Court? Not appeal, but by extraordinary writ? I mean, am I going to be charged with not following the rules if I say, I think you're wrong and I think I need extraordinary relief? Because here's the order that they just issued. It said, as it appears that petitioner's motion to disqualify the district judge has been resolved, such that any motions concerning his house arrest and trial can now move forward, we conclude that our extraordinary intervention is not warranted at this time. So that means that now, that if you're with this record now, I need to go by extraordinary writ petition back to the Supreme Court and say, hey, look, You know, I've got legitimate things. Wilson says I didn't cite specific facts, but he didn't even cite Rippo versus State. That's the controlling law in this. I'm sorry, Rippo v. Baker, is that there's not actual or implied bias. There only has to be the risk of intolerable risk of unconstitutional bias. And I think I've shown that clearly.
Okay.
And so I think
All right,
I
but nobody else does that has ruled on these motions. So again, do what you think is appropriate, but again, I'm not going to allow you to obstruct and impede these proceedings because the state of Nevada, they're entitled to a fair trial and fair proceedings as well. So again, you've been warned. I think the record is clear. I believe I'm required to warn you that your self-representation will be revoked. I think the record is clear that I have made that warning and instructed you that I will not hesitate to revoke your self-representation.
Can I ask for a stay of
So the
proceedings?
next one is, I'm sorry, what?
Can I ask for a stay of these proceedings pending my petition to the Nevada Supreme Court on the motion to disqualify his issue? They said that they're at once you got
any request for a stay is denied.
Okay, can I get that in writing so that I've got the denial in writing?
First of all, I didn't grant any motion or order, but I'm telling you right now, there is no stay that is going to be issued today pursuant to anything that I'm doing. So the next motion is your motion, Mr. Blandino. It's your motion for release from GPS monitoring.
I don't have a motion.
Do you have dates? Yeah, you do have a motion. You want to go see your son Andrew in California?
Well, I didn't phrase that as a motion. I was just, that was a notice to the court that there's an emergency thing I need to do. And if I make a motion to you, it undercuts my argument that you could be fair and unbiased. I don't think you...
Okay, let me tell you something else. If you continue to refuse that this court has jurisdiction, then I will revoke your self-representation. Because in my opinion, that is continuing to impede and obstruct. You can say, I don't agree with Judge Wilson's order or Judge Bell's order or the other. I mean, it's been denied 4 times now. You can say you do not agree with that and you can file an appeal and do whatever you think is appropriate, but you cannot continue to refuse to acknowledge that this court has jurisdiction.
Well,
Do you understand that?
Then I think you're still there's a risk of bias. I want to see you resign or...
So your motion, and I'm going to tell you another thing. You are not permitted to communicate with my office. All these emails, you have been told several times not to communicate with my office. It is inappropriate to communicate with my office. If there is anything that you feel like you have to communicate to the court, I ask that you put it in writing, send it in the mail, or have Mr. Bateman communicate with this court. All of these emails that you have been sending over here, I wasn't even reading them. I became aware of some of them when I read the state's opposition. And apparently they've all been made part of the record. So the record will reflect. We have left side filed many emails that you have sent the court that are ex-party communication. They are inappropriate, and an attorney would never be allowed to send those type of emails.
I need to respond.
Again, do not communicate with my chambers. There is nothing you have to communicate with us.
I need to respond to that, Judge. While there's a motion to disqualify pending, you are a party in that collateral action in which I have by statute the right to at the very least ask to have a judge that could hear that. And if we would have had a judge to hear this months ago rather than trying to go through this Villani and then Jones and Alf and all this kind of thing over the years, if you had been able to agree, well, let's have a judge from another district, then we wouldn't have had all this. And I could have gone to the Nevada Supreme Court quicker. So my position is that by you not following NRS 1.235 and to agree upon a judge, Bell was already recused. She put
and again, I am talking about, again, this is kind of what you do. I am talking about don't communicate with my office. And you say you want to respond to that, and you say something completely
I'm saying how you're
different.
on the motion to disqualify. It's not inappropriate to contact you. The statute.
There is no motion to disqualify. And here's the thing I'm going to tell you again. Do not contact my office. Okay? Do not attempt to have ex parte communications. If there's anything that you need to communicate, you can put it in writing. You can send it to the court through the mail, CC in the other side, or you can have Mr. Bateman communicate with the court. But all this ex parte communications, I don't care what you think of me. So stop reducing it to writing and sending it to the court.
I object to ex parte. They were copied. The DA was copied. Everybody else was copied. So it's not ex parte because they were given knowledge of this, and they had.
I'm telling you, don't communicate with my office anymore.
Okay, that's fine, but it's not.
It's abusive and it's harassment. So you need to stop doing it. Okay? If you don't want me to hear your motion to release you from GPS monitoring, can you let me know that? Because it's on calendar for today and I was inclined to rule on it. But if you don't want a ruling on it, that's fine.
Oh, I'm saying I would be undercutting my own argument. There was no motion. I put it in, I think, as a notice and demand. And I've got an emergency.
So do you want me to take it off calendar?
Well, no, I don't. I'm not saying I want you to do anything there. I want you to resign from the case. I want you to resign from the bench.
All right, Mr. Blandino, I'm telling you right now, you're going to get your self-representation revoked before this hearing's over. I mean, it just appears as though you just refuse to follow the rules or accept that the court has jurisdiction. It is totally inappropriate to say what you just said.
Well, you said you asked what I wanted. I want to have a judge that's unbiased, no risk of bias, that I can present a motion to be able to go visit my son. But I don't have that, and it would undercut my argument if I believe that you were unbiased. I believe you're still biased, and there's a risk of bias with you. So I can't follow. That's why I didn't put it in as a motion. You know,
my misunderstanding. It was on the calendar today. So I will vacate defendant's emergency ex parte motion for release from GPS monitoring.
Wait a minute.
I'll make sure the record is clear.
Wait a minute.
If there's any appeal to the Supreme Court, that I was willing to rule on this motion, and you said you didn't want the court to rule on it.
Directed to Judge Wilson. Judge Wilson did have the authority to do that. Or it was Gregory.
No, he didn't. You should look at the order appointing him. He did not. Okay. Is there anything else? I don't think there's anything else.
There's 2 other motions on too.
Okay, but those are all. Defendant's motion. Oh, I also wanted to indicate that the reason why it took so long is that Mr. Blandino filed another motion to disqualify this court. Okay?
Nope.
Then it goes to Judge Bell. Then Judge Bell assigned it to Judge Jones. Mr. Blandino promptly filed a motion to disqualify Ms. Jones. Then when it went from Judge Jones to Judge Alf, he promptly filed a motion to disqualify Judge Alf. It was abundantly clear that it didn't matter who Judge Bell assigned that motion to. Mr. Blandino was going to file another motion to disqualify, and that's why she sought guidance from Justice Hardesty in the Nevada Supreme Court to get a judge assigned to hear the motion to disqualify. So that is why it took so long, because Mr. Blandino kept moving to disqualify every judge that was assigned the motion to disqualify.
Which is consistent with the position that all the 8 Judicial District Court judges should be disqualified in this matter. Because I'm investigating all of you.
Okay. All right.
I've been consistent.
Let's see.
But the motion for release was to Judge Gregory or Judge Wilson.
The strike affidavits are all off calendar. Yeah, I have it. So Mr. Blandino has indicated he does not want a ruling on the motion for release from GPS monitoring. This emergency motion to Judge Wilson is off calendar. Then the motion to remand the defendant and or any additional conditions of release that has been denied.
Mhm.
And then there's, I don't know why this got put on so many times, and there's state's notice of
I've
motion
got
to
all those,
remand.
Judge. I just
Okay.
need one more ruling for a motion to strike affidavits.
Yeah, that can be taken off
Okay.
calendar.
And
Okay.
then calendar call.
All right, okay, so we are on today for calendar call as well. Is the state of Nevada ready to proceed?
They can be ready to proceed, Your Honor. We have subpoenaed the case. We've issued our notices. We were in a position earlier this week where we believed that the trial had been vacated as a result of the most recent motions to disqualify. So as a result of that, we had taken a step back from further preparing for the trial, but I think that I could determine whether it's possible based upon witness availability to go forward next week.
Okay, how long do you think it will last?
I mean, the state's part of the case would probably last about 2 to 3 days.
How many witnesses?
I'm guessing that we would probably have 6 to 10 witnesses maximum.
Okay. Thank you. Mr. Blandino, are you ready to go to trial next week?
As I already stated, and I've been consistent on this point, I want to stay pending. I demand my speedy trial. You said by my actions previously that I waived that by my own actions, but I don't want a speedy trial. I don't want to have a speedy trial before a judge who has prejudice such as you do, and so therefore, I ask again for the stay pending an emergency writ to the Nevada Supreme Court, because I don't want to wait 20, 30 years like in Echevarria and Rippo and Carlos Gurry and now Bollinger now to get a trial and say, oh yes, Judge Leavitt and the 8th Judicial District, they should have disqualified. So now Mr.
I'm going to ask you a question again. Are you ready to go forward with trial next week?
I need to do an emergency petition to the Nevada Supreme Court. So in light of that,
Whatever you want. Are you ready to go to trial?
no, and I've been denied, just for the record, so that you know. Drew Christensen hasn't got back to me. I've interviewed 3 times with Colette Putnam, who's a private investigator, that Drew Christensen approved funds, but I need investigation, and Drew Christensen's office is not calling me back as to the funds for investigation of witnesses. I'm going to have to call myself, if this thing is forced to go to trial, call myself as an expert witness. I know the DA is going to raise a fit about that.
You're entitled to testify if you want to testify.
Oh, no. Testify as an expert witness.
An expert in what?
I'm an expert in my own religious beliefs after studying in comparative religious beliefs. And my religious beliefs are what motivated the conduct that the district attorney finds criminal, and which is no means is criminal. So I can testify as to Mr. Blandino, religious beliefs, how they've been developing and evolving over the years, and how that his main belief is not to do crimes, is not to do anything that he would not want anyone else to do unto him. And so therefore, to say that he had any specific intent to extort is beyond ridiculous. That Mr. Blandino was only trying to resolve a dispute as to the Commission on Judicial Discipline filing, and following the same metric as what you yourself did in the Rita Dotson method. You stipulated to discipline, and I used those as a template. Judge Wanker.
Mr. Blandino, I got it. You want to call yourself as a witness, so I'm going to ask you one more time. Are you ready to go forward next week, or are you asking for a continuance?
I'm not asking for a continuance. I need to file an emergency.
Then we'll go forward next week. If you don't want a continuance, then we go forward.
Okay, without waiving my right.
I-
Waiving my right. No, let me make it clear. Without waiving my right to a speedy trial, I will waive certain amount of the time it takes to do a petition to the Nevada Supreme Court. And in that regard, I am waiving the time, but not the speedy trial right. And I think I have the right to do that. The case law all says that time is told, and you can still maintain the right, but the time is told. And that's what I'm asking for.
I don't know what that means, time is told.
It means that the time, in other words, if the delay is caused by the other side of the case, then that is charged not against the defendant. If the defendant makes a motion, like if I do a pretrial writ of habeas corpus, then I would have to waive that time that it takes, and you still have the invoked right. So the time is told. It's pretty clear in the case law that you can still maintain the right, but certain time is carved out so that time is charged against the defendant, this time is charged against the state. And so that's what I'm looking at.
It's pretty clear that you are not ready to go to trial next week and that you want the court to continue it. So I can continue it for a short time. I don't know, Mr. Dickerson, do you want to be heard on his request to continue the trial?
So, I mean, we're ready. We can be ready to go next week. If we're going to continue the trial, I would just ask to discuss dates with the court.
We're looking at.
Judge, there's another issue that needs to be resolved. As soon as I have an absolute objection to the district attorney being the prosecutor, because Steve Wolfson is a precipient witness. He helped me in my investigation. He found a judge that was not wearing, didn't have the name tag on there, and this is just a month or two before these charges were brought. I demanded to get that guy's name, and Steve Wolfson helped me investigate and found out who that judge was, and I, in turn, sent a letter similar to what I did with Federico, demanding that he be either apologize or we go forward with something to the Commission on Judicial Discipline. So I'm going to have to call Steve Wolfson as a witness in this matter, as well as Michael Dickerson and Melanie Marlin as witnesses in this case. So I think I sent a notice on this, and I sent the proof.
It's irrelevant. All of that's irrelevant, Mr. Blandino. You need to stop.
Mr. Blandino, I'm going to tell you, just because you say you're going to call a witness doesn't mean you're going to call a witness. You're not going to call me as a witness. I have nothing to do with the underlying extortion and impersonation of an officer. Any testimony I would give would be completely irrelevant. So again, it appears as though you're going down a path where you're going to refuse to follow the rules. So I have September 13th available. So it would be about a 30-day continuance.
It's real bad for me right now. All the way through November is very bad. I would ask for something in January. I think that September is. I have trials. One on the 7th, one on the 13th, three on the 20th, one on the 27th, and we're talking very serious trials, most of them. Several murder trials, multiple shootings.
Okay. How about December 6th?
I can do December 6th.
Okay. Mr. Blandino?
I'm sorry, you want me to say what?
I'm inclined to set the matter over to December 6th. I'm just asking if you have any objection.
Well, I do have objections still with you proceeding forward. I just
All
that
right.
clear.
Again, Mr. Blandino, I am not going to do this every time. If you continue to challenge the jurisdiction of this court after 4 motions to disqualify have been heard and denied, you're going to leave me no choice but to revoke your self-representation. Okay? And then what's going to happen is I'll appoint an attorney, and then you will not be able to talk ever again in court. Do you understand that?
Well, Yes,
It
yeah.
appears as though you have heard and you
You
seem to understand. So I'm
Okay.
going to vacate the August 30th date.
Well,
The
December,
September 2nd date can be vacated as moot. And we will
Yep.
set the trial over for December 6th. And then the calendar call will be,
Calendar call is going to be November 30th. That's going to be at 12:30 if we're still on pandemic schedule.
okay, go ahead. Did you want to say something else?
is you talking to me, Jeff?
Yeah, it appeared as though you wanted to say something. If you didn't, that's okay as well.
You didn't ask for what my side of this trial. I intend to last about. It's going to take about 3 weeks.
Okay. All right. So we have it set to go December 6th. We'll have the whole month.
Okay, that's it,
Okay.
Judge.
All right. Thank you very much. And again, thank you to both
I will-
sides for your patience. I apologize that it took so long to get to this. So thank you very much for being so patient and courteous.
Thank you, Your Honor.
Thanks, Jeff.
Thank you.